And thanks everybody for attending. And we'll get started. So there's essentially, we're going to cover 4 types of business torts today. We're going to cover fraud, libel and slander, misappropriation of trade secret, and then there's a body of tort law called intentional interference with economic relations. But I'll be starting off with fraud. So I'll be peppering in real examples either through our practice, or I may refer to examples that are kind of more popular and more hot button items. But that being said, I'll get started with fraud. So fraud is a very well-known and well-developed body of law. Typically it has 5 elements. But we went with the California version of the code, which has 7 elements here. And so essentially the way that the tort of fraud works is there has to be a representation made by the defendant to the plaintiff stating that a certain fact is true. It could also be that a certain fact was false as well. That could also work. The defendant's representation has to be false, right? So if they're saying that, hey, XYZ is true, or they're saying XYZ is false, then whatever they're saying has to be wrong. And then the defendant has to know that what they're saying is false at the time that they're making that statement. Or at the minimum, there has to be a reckless disregard for the truth of that statement. The intent portion of the elements is actually the one of the most challenging when it comes to litigation, and we'll get into that a little bit later. But the defendant needs to intend that the plaintiff rely on the representation, and the plaintiff has to actually rely on the representation. And then the last 2 elements have to do with damages. The plaintiff actually has to be harmed, and the court has to find that the plaintiff's reliance on the defendant's representation was a substantial factor in causing the harm. There can be some extraneous circumstances leading to the harm. So these are the basic 7 elements of the tort of fraud. Now, there are multiple different ways in which fraud can be in which a defendant can defraud a plaintiff. And we're going to get into some of those. So again, this is the main tort of fraud. It's also called intentional misrepresentation. The representations can be made orally, in writing, or by nonverbal conduct. We don't really see that too often, but it's possible. The representation must ordinarily be an affirmation of facts as opposed to an opinion. So you can't say something like, I believe that the value of this house is $1 million. If you qualify the statement with an opinion, it doesn't work. Now, this third item is kind of the tricky one that I was mentioning earlier. Intent is an issue for trier of facts. That means the jury, or if you do a bench trial, the judge is the one who decides what was the defendant's intent at the time that the defendant made the statement. And lastly, these are just kind of additional elements here. False representations made with reckless disregard for the truth are equivalent to intentional misrepresentations. And again, I mentioned this earlier. You can either have a straight up intent, or if there was a reckless disregard. Now, these are kind of technical terms. We'll move forward to a different type of fraud, which is concealment. So the tort of fraud by concealment is also a well-developed tort. It essentially has many of the same elements, except it's not that the defendant is making a representation of a certain fact to be true or false, but that the defendant is trying to conceal a fact from the plaintiff. We see this happen very oftentimes in real estate cases where when the plaintiff, let's assume the plaintiff is the buyer of a property, and the plaintiff will try to do an inspection before they purchase the property. And during the inspection, their inspector maybe misses something. Maybe there's something structurally wrong with the property. But what the defendant has done is maybe put up a wall in front of where the structural defect is. And if it turns out that the defendant put up the wall a week before the inspection, knowing that there was a structural defect behind that wall, then that's the tort of concealment. That's fraud by concealment. And the plaintiff would have to go through a process of proving that the defendant actually concealed facts, that the defendant intended to deceive the plaintiff by concealing those facts. And obviously the damages and all the other elements would still have to be proven as well. Let me move forwards to another form, which is negligent misrepresentation. Now, typically in the body of criminal law and in tort law, there's always a question of intent, right? And there's different types of intent. As we discussed in the initial description of fraud, there was intentional misrepresentation, where the defendant actively seeks to defraud the plaintiff. And then we also talked about how a reckless disregard for the truth could also be fraudulent as well. In this case, what we're talking about is a negligent disregard for the truth. So it's, if you want to think about it in terms of tiers, this would be the third lowest tier, where the defendant maybe didn't intend to defraud the plaintiff and didn't even have a reckless disregard for the truth, but maybe was negligent in the representation of facts. And typically negligence comes up when there's a duty to ensure that there's a truth to the facts that they're representing. And when do duties come up? Duties typically come up when there's a fiduciary relationship, when there's a contractual relationship already in place. So you don't really see this negligent misrepresentation unless there's already a fiduciary relationship or a professional contractual relationship between the parties. So let's go to the next page where we have an example of this. So let's assume Party A hired Party B to audit Party A's financial statements. And Party B, being an accounting firm, filed audit opinions on Party A's finances for 2019 for 2020. Now, there's a third party in this example, Party C, who invests in Party A based on Party B's audit findings. But it turns out that Party A actually had a $3 million liability on their books that Party B didn't report in their audit opinion. So then you have this Party C who had invested into the A company based on the opinion, bringing suit against Party B. Now, in most cases, this would be a slam dunk because the accounting firm or the audit firm has a fiduciary duty or professional responsibility to the company to make sure that the audit is accurate. So if they make a mistake, they could be found to be negligent in this situation. However, in this particular example, the information being supplied was being supplied only for the benefit of Party A. So a third party relying on that information could not actually bring suit here. And that's actually one of the additional facts to know about negligent misrepresentation is the supplier of information is liable to a third party only if the information is being supplied for the benefit of that third party. So there's a few other nuances with respect to fraud. The reliance has to be both actual and reasonable. So this can come up in situations where the parties are not very sophisticated. If the plaintiff is not very sophisticated and relied on a statement made by the defendant that was just totally absurd, no reasonable person would rely on that statement, then that plaintiff wouldn't really have a good case there. and must have actually relied on it. They can't be an independent cause of the damages. There has to be a direct correlation there. And speaking of damages, they can be calculated in many different ways. So sometimes we look at the difference between the amount that the plaintiff paid and the fair market value of the property at the time of the sale. So this goes back to like that property example where maybe there was concealment. So it turns out that, with the foundational issue, the property was only worth $100,000, whereas the plaintiff paid $500,000 for it. So their damages would be $400,000. We had a case not too long ago where one of the elements of or one of the causes of action that we were pleading was fraud. But it turned out that was our best cause of action that we pled. But unfortunately, the damages associated with the fraud in that case were only like $100,000, because our client really didn't take a large hit from what happened with regards to the fraud. They took a much larger hit on the misappropriation claims. You can also take a look at lost profits. It really depends on what's going on with the plaintiffs and the defendant. You can also take a look at how much the plaintiff has spent in reliance on the fraud. But that's essentially it for pleading fraud. There is also the defenses. There's a 3-year statute of limitation. So the way that the statute of limitations for fraud works is there's this thing is called the discovery rule. It's from the date that the plaintiff or potential plaintiff becomes aware of the fraud. So it doesn't really start accruing until that happens. Let's say I become aware that somebody defrauded me today, and I just sit on that information for 3 years. After that, it's not really possible for me to litigate. Also, this reasonable person standard here as well with regards to the discovery rule. And then lastly, like I said at the beginning, opinions versus representations of facts. So if you say something about like the potential value of an investment, that's not a representation of fact. That's an opinion. For example, I believe that this property will be worth $10 million in 10 years. That's not a representation of fact. That's an opinion. So these are the defenses to fraud. So I'm going to move on to libel and slander. This is the second category of tort that we're going to discuss. So you may have heard these words before. Let me just clarify. So libel is when a defamatory statement is written. So if you email somebody like, hey, you're a jerk, or something like that, that could be libel. Slander statement must be spoken, so it's oral. And these have to be made to somebody else. If I call somebody and I say, hey, you're a jerk, that doesn't count. But if let's say I call Jacob and I say, hey, that guy Vikram is really terrible, then that would be slander. So let's talk about the elements of these. So the 5 components of defamation, it's a publication of statement of fact. So that would be publication, meaning that it has to be to more than just whoever it's about. It can be an email, like a group email, or you can publish something in a newspaper. And actually, we'll get into this in a second. It has to be false, right? So it can't just be, half true. It has to really be false, non-privileged. We won't get into the details of this, but there are privileges. And if you're making a statement that's unprivileged, that's false, that would be a defamatory statement. Has a natural tendency to injure or which causes special damages. Again, damage is always an element of tort. And defendant's fault in publishing the statement amount to at least negligence. So the intent here has to be at least negligence. You don't need to show special damages, especially if, I'm sorry, let me take a step back. If there is a case of per se fraud, and when we say per se, what we're talking about is a situation in which elements 1, 2, 3, and 5 are just easy to prove, especially element number 5. Intent doesn't even we don't even need to look at negligence. If the the statement was per se defamatory, then you don't need to prove special damages. So there's an exception to the general rule for defamation, which is public figures don't really qualify for defamation that's just negligent. That if you make a defamatory statement against a public figure, it really has to rise to a reckless or intentional falsehood. So if you say, something about the governor, and you say, "Hey, the governor is he's a secret alien," that really, you may believe that's true. So I'm not really sure that would really qualify as defamation. Then there's a question of, who really is a public figure? Are police officers public figures? Public defenders public figures? So the rule in California is anybody who thrusts themselves into the public spotlight is a public figure. In California, a private figure plaintiff bringing a defamation suit must prove that the defendant was at least negligent with respect to the truth or falsity of the alleged statement. But again, for public officials, they have to prove actual malice. So let's actually, without skipping forwards, I don't think there's another slide on this. Let me just go through a really quick example that you guys might be familiar with. Currently, there's this guy, I forget his real name, but let's call him the My Pillow guy. So the My Pillow guy has been going on a lot of different networks and saying things about this company called Dominion Voting Systems. And so Dominion is the company that runs they operate and own the voting machines throughout many of the states. And this guy, My Pillow guy, has been saying things like, these guys are a Venezuelan company that's owned by lizard people who eat children in a dungeon somewhere. Something like that. I can't really remember what he's saying. But that is pretty straight up defamation. He's been on news networks saying it. Another individual who's been saying it is Rudy Giuliani. He's been saying things like Dominion voting machines were, they're owned by Hugo Chavez, who's been dead for 20 years. Anyways, long story short, Dominion has sued these guys. And Dominion has sued, I think, Rudy for 2.1 billion or something. And the elements are pretty easy to prove, right? You take the statements that Rudy or My Pillow guy has made, and you put it through the test. And it turns out, so by the way, these torts for defamation and libel have an equivalent for companies as well. So a company like Dominion is actually going to be taking a large hit. It's going to be hard for them to continue to do business in the future because of how these individuals have undermined their character in public. And so we look at the statements. The statements were published. Now let's take a look at some of the defenses. Okay, so some of the defenses that are possibly available, I don't think they're going to be available to these guys, or if the statement was an opinion, that's one. So the other one is, what if there was some substantial truth to it? And then there's a fair report privilege, and that is if the reporting of the truth of the matter was potentially true as well. That's not even a good example here. So there's also an important provision under the Decency Act that may protect you if a third party, not you or your employee or someone you're acting under your direction, posts something on your blog or website that is defamatory. So we don't have another section on this, but if for example, in the comments section on our blog, somebody writes something that's defamatory, we're not going to be liable for that. So there's some protections there as well. But the biggest protection really is the opinion one. Oftentimes, somebody will say something as a matter of fact, and oftentimes people will say, "Hey, it's my opinion." So there's definitely ways to make the same statement, and I'll turn it over to Vikram.
Hi, everyone. Yeah, so thank you for your time, Hooman. I'll be talking today about misappropriation of trade secrets. That's another business tort. The basic elements is the plaintiff has to claim that he or she or it was a owner or a licensee of some sort of trade secret. Then the plaintiff claims that this information that's a trade secret was misappropriated by the defendant. Misappropriation essentially means some form of improper acquisition or use of the trade secret. Now, the plaintiff also must claim that defendant's misappropriation of that trade secret caused him or her harm, and the defendant also profited by those same means as well. And then the defendant can deny these claims and also can make affirmative defenses. So the question is, we have a definition of misappropriation here. Like, what could a trade secret be? Trade secret could be something like a customer list, right? If it's like some sort of confidential customer list, it just can't be like, okay, well, I'm going to sell tires, so let me just call up Tesla and Nissan and Toyota, right? I mean, that's not what we're talking about here. But if you're some nuanced company and some very nuanced customer lists with pricing and all that, that's really what we're getting at. It's you kind of may have to see, it's maybe a bit subjective, but I think the more confidential it looks, the more of a trade secret it's going to be. So here are some of the essential factual elements the plaintiff must prove. Again, the plaintiff in some way, shape, or form owned or was a licensee of this trade secret, that the defendant improperly acquired the same thing, and the defendant was unjustly enriched, and the defendant in some way, shape, or form acquiring it and becoming unjustly enriched by this using the trade secret. So like, for example, a customer list, and the defendant acquiring it, and now they're calling up the customers, they know the pricing, and they pretty much undercut the plaintiff, right? Here, a trade secret defined. So I kind of went into a little progression of thought before, but here it is definitively what a trade secret is. The information is first of all a secret. The information had actual or potential independent economic value because it was a secret. So I guess that's number two kind of qualifies number one, right? Number one's a bit vague. Okay, what's a secret? I mean, do I have to whisper it in your ear? I mean, you know what I mean? What is really a secret, right? But number two really qualifies it and makes more sense that somehow this piece of information had some kind of economic value, right? Like they say with the KFC, there's like 31 ingredients to make that chicken. And honest to God, I think I read about it. It's held in some secret vault somewhere, how to make that KFC chicken. So that is a billion-dollar trade secret right there. And obviously, the number three kind of ties into the example I just used. You have KFC putting those 31 secret ingredients about how to make their chicken in a secret vault somewhere. So if someone's trying to break into it and get in there, it's pretty obvious KFC's making it known to the world, hey, this is a trade secret here. The secrecy requirement. The secrecy is required to prove that something is a trade secret. So for example, like within a company, right? So maybe the people, not all the employees at KFC know the secret recipe, right? But the people in the corporate office that maybe work near that vault, they may know what the the secret to the recipe is, and they're kind of monitoring the vault and keeping it a secret. So those people may know it. It also may be disclosed to non-employees. Perhaps they're licensees, for example. And if you have a licensee, I'm going to definitely have a contract with you saying, hey, this trade secret information I'm giving you, you're keeping it confidential. If you divulge it to anyone else, you're going to be held liable and you're going to indemnify me, and all those repercussions are going to happen. So it can be disclosed to non-employees. So, if it's a licensee, I'm disclosing that trade secret to you because you're going to give me something in return. You're going to give me some sort of consideration, some sort of cash, monetary compensation. But again, it shouldn't be known to everyone in the public, right? So again, you and I, Hooman, we just can't. We can go online and go on Pinterest, and we can try to find the best way to make the KFC chicken, but we'll never know the exact way because that secret recipe is held in that vault and only a certain number of people in this world know it. Reasonable efforts to protect the secrecy. So this is another way a plaintiff can kind of prove that, hey, this was a legitimate trade secret. They're able to establish that they made a lot of certain efforts to keep it a secret. So, today we live in the digital world, right? A lot of people don't keep their secrets in a vault. People sometimes they keep it in their phone. But, we live in a digital world. A lot of times people, corporations, businesses, they're storing their trade secrets in the cloud. Right? A lot of coding, a lot of software companies, a lot of information and data and billion-dollar ideas and technologies all stored in the cloud. But again, what are they doing to keep that cloud safe? There are firewalls there. There's all these, McAfee or Norton or antivirus software, all these kind of implementations in security infrastructure in place to make sure that this does not, a hacker cannot try to access it, to really put in some time, money, and effort to keep these trade secrets a secret, for lack of a better word. So this requirement applies to each item that the plaintiff wants to keep a secret, which makes sense, right? So, if it's 31 ingredients to make that KFC recipe, you need to the whole 31 items need to be kept securely. I mean, if you keep 15 of them out the door, how can you argue that the other 15 ingredients are a secret? It doesn't make sense. So you need to kind of keep everything cogent. And again, this is a very subjective thing. Like, what is reasonable efforts, right? What are the reasonable efforts you took to keep this information a secret? But I think it's pretty obvious, right? Like, look, if I'm walking around with back to KFC again, I have that recipe right here in my hand. I'm walking around and I take a nap on the bench in the park and I keep it on my chest and I fall asleep and it flies off in the wind. Someone picks it up. Boom. I mean, come on. It's pretty obvious. I made no effort at all. But, if I keep it in a secret vault in a bunker 100 meters underground, it's very obvious I'm making a lot of effort to keep that a secret.
You can have something that's a trade secret with respect to one party that's not a trade secret with respect to another party. So, for example, let's say in that KFC example, they want to outsource the production of the chicken to one of their vendors, then that's no longer a trade secret with respect to that vendor. It might be a trade secret with respect to, Popeye's chicken, but it's not a trade secret with respect to like chicken manufacturing company. So,
yeah, definitely agreed. So again, here are some of the factors we consider to assess reasonable efforts. Again, you have to look at factors and things like that because, again, reasonable efforts is a very subjective standard, right? So when we're talking about, some sort of technical information, whether these documents and computer files were marked with confidentiality warnings. I mean, that's pretty straightforward. I mean, if a corporation or someone could just do that, it'd be very easy to prove in a court of law, hey, Your Honor, look, I put a big rubber stamp on it, confidential. I mean, what more do you need to argue reasonable efforts, right? Again, also, if it's in the case of you have employees or family members, I mean, here the second bullet point, it says employees, but I'd say even family members. If you told your employees, if you told your son, your daughter, your uncle, hey, I'm giving this to you, it's between you and me, I'm telling you it's secret, and then they go ahead and let it out known on the New York Times the next day, well, you have a very good case that you took reasonable efforts, right? Again, restricting access. That's back to my example of firewalls, right? I mean, and then of course, keeping the information secure, right? My perfect example, laying asleep on a park at the bench, in downtown New York City, I mean, with the recipe on your chest, just laying there, and someone, just flies off in the wind. I mean, you can't do something like that. You gotta make some efforts to protect that secret. Some more factors. This is a perfect example. I mean, if you have someone sign a confidentiality or non-disclosure agreement, the beauty of that is you have two causes of action. Now you have a cause of action for misappropriation of trade secrets, and you also have a cause of action for breach of contracts. So that would be a really great idea for any company to do, because you're giving your attorney two causes of action to sue off of right there, instead of just trade secrets, you have breach of contract. Standard F is, again, the actions the plaintiff took to protect the information. If you're keeping it in a vault in a bunker 100 meters, in a basement somewhere, if you're storing it in a cloud in the AWS or Azure or something, and you have all these firewalls in place, you're pretty much letting it known to the world and to the judge and to the jury that you've taken a lot of reasonable effort to protect the information. And then the extent the plaintiff took, obviously, if someone has it buried 100 meters underground in a basement, in a vault, it's very obvious, hey, this guy's taken a lot of efforts, invested a lot of time, money, and resources to make this happen. So he's taken a lot of reasonable measures. And, and also the measures the plaintiff did not take. I think that's a good point in bullet point H is, what didn't you do? I mean, like I said, if you just fell asleep on a park bench and let that trade secret fly off in the wind, then, well, you're letting it known to be everyone that you really don't care that much, and this lawsuit is just completely frivolous, possibly. So, yeah, the presence of or absence of any of these factors could really help tip the needle, if you will, as to whether you made a reasonable effort to protect that trade secret. Misappropriation by acquisition, right? So essentially, the whole concept of this slide, I guess, is how did the defendant misappropriate the trade secret? So I guess this point of this slide is kind of emphasize the point that it used they may have used a third party possibly to acquire the information, maybe some private investigator, maybe they found an inside employee and they bribed them. But somehow the whole point of pleading this element is establishing that somehow the defendant took possession of his trade secret. So if it's a confidential PDF file, perhaps it's, somehow the defendant got on the computer, put their zip drive in, downloaded it, and took possession of it. If it's written KFC recipe written down on a handwritten note in a vault. Again, that maybe entails the defendant, welding through the safe, breaking it open somehow, doing some sort of inside job, and breaking open the vault and acquiring it. But there has to be some way that defendant acquires this trade secret information. The next tort I'm going to cover, and the last one, is it's intentional or negligent interference with economic relations. So we're going to kind of lump them together because it's just a matter of degrees here between intentional or negligence. But essentially what it entails here is the plaintiff has to claim that the defendant caused a third party to breach the contract with the plaintiff.